Hello everyone, and thank you for tuning in to the Firearm Firm channel. I'm attorney James Phillips, a former prosecutor and one of the founding partners of Katz & Phillips PA, also known as the Firearm Firm. And today we're going to be discussing the ruling that came out this past Monday in the Mock v. Garland case that is challenging ATF's final rule on stabilizing braces. But before we jump into our discussion for the day, be sure to show your frustration with ATF's overreach by clicking on the like button. And if you enjoy staying up to date on all things, whether it's good or bad, affecting your right to bear arms, be sure to subscribe to the Firearm Firm channel by clicking on that subscribe icon located down in the bottom right hand corner of this video. Before we get into the order issued this past Monday by the United States District Court for the Northern District of Texas, let me first give you a brief rundown on what has occurred in the Mock v. Garland case. Two named plaintiffs, the Firearm Policy Coalition, FPC, and Maximum Defense, Inc., filed a lawsuit and moved for a preliminary injunction challenging ATF's final rule for the following 6 reasons. Number 1, that it infringes on the individual FPC members' Second Amendment rights. Number 2, that it violates the First Amendment. Number 3, that it runs afoul of the Fifth Amendment's due process guarantee. Number 4, that it violates the structural power vesting provisions of the Constitution. Number 5, that it violates the Administrative Procedure Act, APA, as it was issued in excess of ATF's statutory authority. And finally, that it violates the APA's procedural requirements because it was not a logical outgrowth of the proposed rule. Now, unfortunately, the Northern District of Texas originally denied the plaintiff's request for a preliminary injunction on the grounds that they had failed to demonstrate a substantial likelihood of success on the merits of any of their allegations or claims. And of course, the plaintiffs appealed, and on August the 1st of this year, the United States Court of Appeals for the Fifth Circuit stepped in and reversed the Northern District of Texas order denying the preliminary injunction and decided in favor of the plaintiff's logical outgrowth APA claim, holding that 1, it is relatively straightforward that the final rule was not a logical outgrowth of the proposed rule and that the monumental error was prejudicial, and number 2, that the final rule therefore must be set aside as unlawful. The Fifth Circuit remanded the case back to the Northern District of Texas with instructions to assess the remaining preliminary injunction factors and rule on the plaintiff's motion in light of the circuit panel's decision, and do so within 60 days. The Fifth Circuit also placed no limitations on the matter that the Northern District of Texas must address on remand, and they provided no indication of what decision the Northern District of Texas should reach. Now, I did previously do a video discussing the Fifth Circuit's ruling, which can be viewed by clicking on the link above, or if you want to finish this video first, I will put a link to that video down in the description section to this video. So this past Monday, October the 2nd of 2023, the Northern District of Texas entered a 38-page opinion and order on the plaintiff's motion for preliminary injunction, which can be viewed by clicking on the link down in the description section. For those of you who just want to know the end results and don't care about all the details, the Northern District of Texas did grant a preliminary injunction in favor of the plaintiffs and all the members of Firearm Policy Coalition and customers of Maximum Defense Industries, whose interests they've all been representing since day one of the litigation. All right, for those of you who have a longer attention span, let's jump into the order itself. As we've discussed in many other videos, in order for a court to enter a preliminary injunction, the party requesting the preliminary injunction must demonstrate 4 things. 1, a substantial likelihood of success on the merits. Number 2, a substantial threat of irreparable harm. Number 3, that the balance of hardship weighs in the movement's favor. And number 4, that the issuance of injunctive relief will not disserve the public's interest. Once a court determines that the moving party has met all of those elements, the court must then determine the appropriate scope of the prospective relief, which is dictated by the extent of the violation established. As to the substantial likelihood of success, the court really didn't have to spend any time on this because the Fifth Circuit Court of Appeal already decided that the plaintiffs had demonstrated an actual success on the merits of their APA challenge to the final rule, so the Northern District was bound by that finding. So now the court had to determine whether or not the plaintiffs will suffer irreparable harm if a preliminary injunction was not granted. The court first looked at how the individual FPC members and the named plaintiffs would suffer and did an extensive analysis, finding that the threat is twofold. First, they would all face a sustaining permanent and non-recoverable cost for their compliance with the unlawfully issued regulation. And number 2, they would suffer impairment of the fundamental right to keep and bear lawful arms in self-defense. Now, I'm going to skip over the court's analysis of the non-recoverable cause portion and jump straight to the court's reasoning that the plaintiffs would suffer impairment of their fundamental right to keep and bear lawful arms in self-defense, because that's really what we care about, the 2A argument. The court started off with the fact that when an alleged fundamental right is either threatened or in fact being impaired, the plaintiff is substantially threatened with irreparable injury per se. Because once an infringement has occurred, it cannot be undone by a monetary relief. The court then went on to write that the alleged impairment need not be severe or prolonged for the loss of a constitutional freedom for even a minimum period of time unquestionably constitutes irreparable injury. The court then dives into the fact that the Second Amendment prohibits the government from infringing upon an individual's right to keep and bear arms for self-defense, and that this protects an individual's possession and use of weapons that are in common use at the present or current time. The court found that brace pistols subject to the enforcement of the final rule are in common use today, and the ATF agreed that these weapons that are involved in this litigation are usually lawfully bearable pistols absent a rearward attachment, and therefore these pistols are lawful, and a stabilizing brace does not somehow alter the status and effectively strip these pistols of their Second Amendment protection. Now, fortunately, ATF didn't agree to that part, but that's what the court found. Next, the court looked at whether or not maximum defense and other commercial FPC members face substantial threat of irreparable harm absent injunctive relief. The court namely found that they are threatened with permanent and non-recoverable cost of compliance with an unlawfully issued regulation and a substantial financial injury which could lead to permanent closure of their business. The court found that these irreparable injuries flow from the threat of enforcement of the final rule, and that threat is ongoing, vulnerable to intense exacerbation, and interdependent with a vast commercial supply chain network. As to the last two requirements to grant a preliminary injunction, the court found that enforcement of the final rule against plaintiffs, neither the government defendants nor the public has an interest in enforcing a regulation that violates federal law. Needless to say, this is a huge victory for the 2A community. I do want to make sure everyone keep in mind that this is just an initial victory. It's not the ultimate conclusion to the case. A preliminary injunction is just a victory until we get to the end result. So we don't know what the end result will be, but I will tell you that usually a ruling on a preliminary injunction is a good testament as to what is going to come out in the case. So things are looking great for us and bad for ATF, which always makes everyone happy. Now, you may have many questions about this video, preliminary injunctions, the Mock v. Garland case, or just any other Second Amendment related question. And if you do, be sure to leave them down in the comments section below, or you can email your questions directly to us at questions@thefirearmfirm.com. Until next time, stay armed and educated.